Let's go. So, welcome everyone to the session about the New South Wales legislation changes. My name's Nicole, and I am the CEO of the Institute, and I'm here to introduce David Newey, who's going to be leading today's session. Now, David's a member of our board, and he's also a partner at Newey Bond Lawyers. He has managed law firms for over 30 years, and he's spent over 4 decades advising businesses and individuals on how psychosocial hazards, workplace culture, and psychological injury claims intersect with the duties and legal obligations owned by employers and businesses. David, we are very grateful for your time. Thank you so much for this. There is a lot of interest and a lot of change that has recently happened. So I'm going to pop myself on mute if everyone else can do the same. As I said, pop your questions in the chat, and if we get time, we will go to those with David afterwards. But David, thank you again, and over to you.
Thank you, Nicole. Greetings, everyone. And you have come along to one of the most active, difficult topics for people to come to grips with at the moment because of the amount of legislative change we're going through. And it's rather horrific and it's rather complicated, but I hope to give you a few takeaways today to look at where you might get some extra information, give you a couple of tips, and give you a little bit of a heads up on how there is a very different landscape for employers. I'll focus predominantly on employers' responses to the legislation. I'll pick up how it impacts on employees, but generally that's where we're going to play today in our discussion. So psychological injuries come from all sources, and we've got a little slide there just to give us all a heads up on where we may see a psychological injury as a consequence of something that occurs at a workplace, be it bullying, harassment, excessive works, and those three fall into a very special category now in New South Wales, be it a traumatic incident that people are exposed to, whether it's a close family member, a relative, and a witness and a rescuer. All of these people come across traumatic events during the course of their work that potentially lead to psychological injuries. And then the claims that come out of it, some fall within the workers' compensation system, some outside of that system and are covered by different insurances. The example there is if someone loses a loved one at work and they suffer a psychological injury, their claim doesn't fall within the workers' compensation legislation in New South Wales. It falls outside of that. So because they're not a worker, it's a workers' compensation scheme. So those nervous shock claims fall outside the workers' comp system. And when a dependent does lose someone, that falls inside the system. So we might find that a family member, a wife, a husband, a child who has suffered a psychiatric injury sees that they're bringing a claim against an employer of their lost one, and they receive compensation outside the workers' compensation scheme. So it doesn't apply to those, but their claim for loss of dependency does fall within the workers' compensation scheme. So you can already see it's a complicated scheme just from the start, and that just turns on who is actually injured and how they are injured. So that's what we're talking today about, psychological injuries and what we're doing. So we have had a raft of changes. We have changes to the New South Wales Workers' Compensation Scheme. The first trick is there is a group that we've had exempted from that scheme. They are the police, the firefighters, paramedics, also coal miners are out. So these are people that are not caught by the psychological injury changes to the workers' comp system. They don't escape other changes, but that's where it is. We have, whoops, we'll go back. We have the Industrial Relations Commission has also inherited a number of additional changes in jurisdictional issues. It now will decide whether or not there is a relevant conduct injury, relevant conduct being excessive work, bullying, and harassment. So it has the sole jurisdiction to determine that, not the claim entirely, but just whether or not there has been that conduct. Then it flips over to another dispute process. So now we have two dispute processes for a workers' comp claim, depending on the nature of the psychological injury. Once again, another two-tier step. In addition, the Industrial Relations Commission has inherited an additional jurisdiction for work health safety matters as a consequence of the changes. So that will allow disputes over work health safety matters to be ventilated in the Industrial Relations Commission. And a worker can bring them, a union can bring them, the employer can bring them, and they're quite significant. And I'll touch on that a little bit more later. And then when we come to the work health safety area, we've got a code, most significant issue. So that's where we have. Digital monitoring now is dealt with separately. So there is a obligation in relation to digital monitoring, and offences created if you don't comply with those laws about providing access to people that come onto site to investigate what's happening with your digital monitoring, particularly relevant where we've got remote working, attempts to monitor people that do remote working and the like. And in addition, under the WHS Act, there is much more power for unions to become involved, in particular with issuing notices, bringing prosecutions and the like. So we're going to have a look at some of that today. So where we go to the changes, I look at the reforms for workers' comp. They're easy. We now have different excesses paid by employers for claims. That's one change. Two, there's always been an obligation to provide suitable duties to injured workers. Now there is a right for Safe Work to issue improvement notices, and they've doubled the penalty for not complying with improvement notices, requiring you to provide suitable duties. That can be very challenging when you have a bullying or a harassment or an excessive work demand claim. So the penalties are double in the event that you don't comply with an improvement notice. In the workers' comp system, there was great concerns from employers that the defences that were made available, that employers acted reasonably and their actions were reasonable management action. Those defences now have been strengthened. There is no doubt of that. Those defences are obviously untested because we haven't seen any proceedings. And the cases that proceed will develop and inform the interpretation of the new provisions. So we are some time off before we will get to those, but that will start to occur. So eligibility for workers' compensation and ongoing workers' compensation has been changed. Entitlements have been changed, and there is little doubt the entitlements for those who have been injured with a psychological injury have been significantly reduced, from both the entitlement to bring a work injury damages claim and also the number of weeks that you will receive benefits and the amount of compensation for medical expenses you can receive. We've got a two-tier system now where one type of psychological injury sends you on one route and the other type sends you on another route when it comes to a claim and a dispute, which complicates things, but it's relatively straightforward, but it is a complication because all claims are not the same. In addition, there's been the introduction of a medical expenses must be reasonable and necessary, not reasonably necessary, which was the original test. So it is different, and it'll be interesting to see how that plays out, particularly in the psychological injury framework. For example, regulations have been passed that have listed a number of forms of treatment that are no longer compensable, where in the past they might have been compensable. Now, use of cannabis is an example. Next, they've introduced a new system where when you get an assessment, which is a threshold assessment, which gives rise to entitlements, you can only have one go at it, unless there's very special circumstances, but generally you should assume there's one go at it. And so that makes it very challenging for someone to bring a claim too early, because if you bring a claim too early to get your impairment threshold assessed, then potentially you are stuck with that assessment forever. Remembering that you will only ever get an impairment assessment where you've got maximum medical improvement, but some people do deteriorate after they have maximum medical improvement. So that's an issue. The benefit for employers who have had difficulties managing psychological injury claims so long is a 2-year freeze on workers' comp premiums in terms of increases on the formula that is used. And finally, it's easier to settle up a workers' compensation claim by way of a lump sum, which we call a commutation, and that's been made a little bit easier. So they are the key reforms. They're the reforms you'll read about every time you look at a piece of paper to consider anyone's publishing information, but they are found all over the place. They are not found in one single place, which makes it challenging to know what to do and where to find the information. Now, in terms of the Work Health Safety Act, we now have a duty to comply with codes, not just the Managing Psychosocial Hazards at Work code, but other codes. And that's found in section 26A of the Work Health Safety Act. We also have new legislation that introduced regulation and obligations in regards to digital work systems used to monitor work. Those changes were inserted into the Work Health and Safety Act as well at section 21A. In addition, the Industrial Relations Commission now has power to deal with disputes that can be referred by unions, workers, people affected by safety issues, and the like, where they've had a go at trying to resolve the issue at work and didn't get anywhere, including work safety committees that interact with employers. So if there's a dispute, there is now a journey off to the Industrial Relations Commission, which has jurisdiction to deal with safety matters. And just to give you a feel of how wide the disputes can extend to, matters about work health and safety arising at a workplace or from the conduct of a business or undertaking, and the matters not resolved after discussion between the parties to the issue. I think that's pretty wide. So if you're chatting about health and safety and you can't resolve a dispute with your employer, off goes the worker, off goes the Health and Safety Committee, and there's a way to deal with that in the Industrial Relations Commission. And they can conciliate it, and if necessary, proceed to a hearing in regards to the matter. Another part of the changes are that the unions now have power to prosecute for breaches of the Work Health Safety Act. That would include breaches of the Managing Psychosocial Safety Hazards at Work Code. rather concerning that unions have that power. I would have thought for some employers that are on unionised sites, even if sites are not unionised, where unions represent workers, they will have those powers to prosecute. They're not unfettered. They're not a first go. In the event that Safe Work brings proceedings, those powers are dissipated and removed because the regulator has the power to bring the prosecution. But if the regulator doesn't bring the prosecution, then you may find that a union can. One of the tricks about a union having a power to do so is that it can make an application to the court in a successful prosecution to have a component of the penalty paid to the union. So there's a financial incentive there for unions to prosecute. So that's a balancing exercise, but there certainly is a much stronger power. In addition, now health and safety representatives at the workplace can issue improvement notices to an employer, and as soon as the employer gets an improvement notices, it has to pass it on to the regulator. The regulator will then have a look at the notice and is obliged to attend the worksite within 7 days of receiving that notice. So that's another biggie to deliver some control and also some responsibility to health and safety representatives who now have, in my view, a larger stick that can be wielded in the event that something is needing to have a look at. So what's new in workers' comp? Reduced entitlements, increased thresholds, reasonable necessary test, new definitions. We never had definitions in the Workers' Comp Act about certain forms of conduct like relevant conduct or bullying or harassment. It was very much informed by what the courts interpreted bullying was without a definition. We now find ourselves with definitions. In addition, we find ourselves with some additional defences, not just the 11A defences, but more. One of the interesting problems with the jurisdiction until the changes occurred was that the perception of a worker was a very significant driving factor on whether someone would be entitled to workers' compensation for a psychological injury. It's how they perceived the actions towards them rather than what the actions were. So this was a continuous battle for employers to deal with, because a worker would say, well, I might be wrong, it wasn't in relation to demotion, promotion, but that's how I perceived it. And so that was seen to be a challenge for employers. That's been addressed, and I'll cover that a little bit later when we have a closer look at that. The next, there was debate on whether or not workers would be funded where there was going to be a industrial relations dispute over relevant conduct. There is funding for workers. It's at the same levels that a worker would, or workers' lawyer would be paid in regards to a dispute in the Personal Injury Commission. So therefore, there is some money there. It's not a lot, it's about $7,000. So that's what a lawyer will receive for acting for a worker in one of these disputes. But an Industrial Relations Commission dispute over relevant conduct can take a lot of time. No, not a lot of time if it's conciliated and resolved, but if it proceeds to a hearing where there are a large number of witnesses, which might be over a number of days, the current funding proposals, which are found in guidelines that have been published, only provide for the $7,000 odd. Now, that's going to be a challenge because it puts a workers' lawyer in a conundrum when it comes to the conciliation. Take the $7,000 for the conciliation, or go to a hearing and spend 3 days and all the preparations you need to do to run the hearing. I believe that we'll get submissions made by workers and Law Society and others to revise those guidelines in due course. I think the guidelines will be relatively temporary and they will be looked at further down the track. And I think the plan was to have that all done by October, but it is a bit of a moving feast. So then we come to claims in workers' comp. So we've got a two-tier system. Relevant conduct claims are part of relevant events, but you only get a psychological injury, workers' compensation entitlement if you've got a relevant event. So first test, is it a relevant event? Second test, if it is a relevant conduct, and if it's relevant conduct, you go off into the separate dispute process. We have the exempt workers, which I talked about previously. We have a fast track process for claims, which I'll cover off on, but they only apply to relevant conduct claims. So you can have a person who's got a significant psychological injury that has been caused by a traumatic incident that doesn't get the fast track. So the fast track is designed to resolve the relevant conduct component of the claim. So that's how it will play for a little while. And as I mentioned earlier, the exclusive jurisdiction to deal with whether or not there's been relevant conduct now rests with the Industrial Relations Commission. In relevant conduct claims, that means that employers and their insurers potentially face a dispute in the Industrial Relations Commission, and if that dispute is found in favour of a worker, they may still face a dispute in the Personal Injury Commission. So it becomes quite complex. In addition, as part of the reforms, New South Wales government recognised that for businesses that were not part of a constitutional corporation or governed by the Fair Work Act missed out when it came to stop bullying orders and stop harassment orders, and therefore they decided to create a jurisdiction and entitlements for those people who can't access Fair Work to bring proceedings in the Industrial Relations Commission seeking stop bullying orders, seeking stop harassment orders. But the difference between the jurisdiction in Fair Work and in the Industrial Relations Commission is, if you look on the right of the slide, you can also get damages up to $100,000 where there has been bullying and there has been harassment. And in addition, you can get civil penalties. Who is affected by those? Government agencies, local governments, people employed by partnerships, all of the people that are not governed by the Fair Work Act, because the corpse law, which basically triggers all the companies and brings it into that, you now have an entirely different problem. Now, with damages for government agency employees, and you don't get it twice. You can't get the workers' comp damages plus the damages for stop bullying. So it becomes hard for lawyers advising those workers to select which way they can go. And all bullying, harassment, and excessive work demand disputes, where they go through claims processes and are still disputed, end up in the Industrial Relations Commission, at least for determination of relevant conduct. Now, there's a little bit of a loophole that people won't know about unless they look at the legislation very carefully. The intent was to have the IRC determine relevant conduct, but there's also a provision that says where there is a finding of a court tribunal or other entity about bullying or harassment, then that's binding on the employer. So we might find that people don't go off to the IRC and they run off to the Fair Work Commission, where the Fair Work Commission has access to bullying orders and stop work orders, because you can get on very quickly in those circumstances and you can get a decision made very quickly, and that could be something that's a challenge for employers because your workers' comp insurer will not be managing that. And so that will fall to the employer. So they are the changes that are on foot at the moment. We have a positive duty to comply with the Psychosocial Safety, Psychosocial Hazards at Work Code. We have a duty to comply with the digital work system requirements, and we are facing an enhanced IRC jurisdiction. And for those of you who were reading the paper over the last couple of days following the Labor Party's Thursday Talkfest, you'll see that we are also facing a new workers' court that the government federal will be introducing. We haven't heard everything yet, but that's another that's going to feed into the equation of psychological injuries potentially. Too early to tell whether or not anything will go there. Now, whilst we're dealing with workers' comp, there are a whole lot of things that will continue to apply, which were in play before the changes came. Some of these are not well known and are not well used, but generally, you can't terminate someone within 6 months of their injury. It's an offence. Now, that becomes very significant where you've got a relevant conduct dispute, because if there is no relevant conduct, there is no injury. So therefore, that is no compensable injury. Therefore, that termination provision wouldn't apply. So it becomes a very important issue, that dispute in the IRC, because you might be a few months in after the injury, and if that's the case, you won't be prevented from terminating a worker anymore. That's something that will come into play. Another provision people do not quite understand is that if you do terminate someone because of their injury, once again, it's got to be relevant conduct, you've got 2 years to come back and ask for reinstatement to a similar position. Once again, not a well-used tool, but it's available and it gives rise to issues. And there is disputes, but very few. And the disputes that have gone to hearing have all been relatively successful in obtaining a reinstatement order. If you're cynical, an application for reinstatement could be settled by a bag of cash. And so that might be a motivating factor for people to bring those claims, but that's something that you face. And those claims are not covered by your workers' comp policy. In addition, we've got unfair dismissal claims that can be brought if you are terminated, if you seek to exercise a workplace right in respect of bullying, harassment, your rights generally, and you are treated adversely, you can bring a claim in the Fair Work Commission. Those are not managed by your workers' comp insurer. If you're a whistleblower and you bring a claim and you're seeking compensation because you've been treated adversely, they're not covered by your workers' compensation insurer. The interesting thing is I can, as a person who brings an adverse action claim, if I've suffered a psychiatric injury because of that adverse action, I can get compensation for personal injury damages if I can link those damages to that adverse action. Can't get damages like that for unfair dismissals, can get damages for that for whistleblowing. It sounds very complicated. It is very complicated. Where do you go to get a little bit of the information about the scheme and the changes? First of all, you will see everyone talking about all the amending legislation. It's very hard to read amending legislation because it says go to clause 7, add these 3 words after it and do this. You don't need to go to that amending legislation really. On the left-hand side, the legislation that has been amended that has all the rules in it, the Workers' Compact that's been in since 1987, the Work Health Safety Act that's been in since 2011, and the Industrial Relations Act that's been in since 1996. And all those amendments have been stuck in the Act. Everything that doesn't apply deleted, and you can now read it as if it's there. So that's interesting. And on this slide, I've actually got hyperlinked. I'm not sure what the plan is to do with the slides, but I've included hyperlinks. In addition, when I look at the Industrial Relations Commission, we now have guidance notes on how to bring these new types of claims, WHS matter claims, relevant conduct disputes, prosecutions by unions and the like. We have new forms, we have practice notes, and they've all been published on the IRC website. And that's easy to get. ILARS is the entity that funds workers for their legal costs. There's been an amending instrument published, and that's the link to it. And as I say, it's temporary. We have a new workers' compensation regulation. That's important to look at, and people should look at that. Under the new provisions, the insurer's lawyers, that is iCare's lawyers, must certify that the claim that is being disputed, there are reasonable prospects to dispute the claim, and that the costs of disputing the claim are justified having regard to what's in dispute. So now that's an interesting one. It'll be interesting to see how that plays out, because the cost of disputing something might be $15,000, and if the amount in dispute is only a small amount of treatment, it will be very hard for iCare's lawyers to provide a reasonable prospect certificate over that dispute. So that's going to be a challenge for employers that wish to dispute things, where the control of the dispute is going to rest largely with iCare and its lawyers. There's also a new workers' comp claim form, so that's accessible where I gave that link, and it's got a whole section to deal with psychological injuries. There's new workers' compensation guidelines published by CIRA that started on the 1st of July, and they're a good place to start to look. You have to be careful when you go to the internet to see some of this information. One, AI is pulling the information from all sorts of places. Two, it's not necessarily pulling it from the right places. From what I've seen, some of the information that comes out from AI is clearly wrong. Some of the information that's being quoted by people is being quoted too early, and some of it has no reference to the time that it was published. And I have to say, the scheme has been moving and evolving over 18 months. So be careful when you do go look at information, because it possibly is well and truly outdated. So, Industrial Relations Commission, stop bullying, stop harassment, and is there relevant conduct, and are there WHS matters? Off we go to that jurisdiction to deal with all of those. It's a new jurisdiction for that court. They probably are resourcing up at the moment expecting these, but as an example, we're not going to see any relevant conduct disputes for a couple of months, and that's because of the time frame to make decisions. Stop bullying, stop harassment, nothing's bounced up that at this stage, but once people get used to it, it will. That's been in place for a while. It's not just starting. From recollection, it was in October 25. These came into play. Same with WHS matters. So we don't have a build-up of litigation or disputes yet, but lawyers take a lot of time to get used to things and then start to ventilate. disputes. So we can look at those. Duties to comply with the Managing Psychosocial Hazards Code. It is such a significant change. It is such a significant change to make it an enforceable code where a breach of the code can result in improvement notices, prohibition notices, and prosecutions, and probably blueys for infringement notices. Quite significant. And to give some of those powers to unions will complicate what the regulator's response is, because that will empower unions to drive regulators to take proactive action against perceived breaches. And I say perceived because there may be reasonable management action, but that's not an issue for a WHS breach. That's a matter for the delightful workers' comp claim. And I have some concerns, as do many businesses, over providing access to my systems to unions representatives, where you are using some information to track and record what people are doing, and that leads to potential claims for psychological injury when it comes to psychosocial hazards. It's a very challenging issue for businesses, how they're going to manage access to digital systems, how they're going to deal with privacy obligations, and how they're going to design their systems so they can still capture what they need to capture for their business, e.g. an insurance company that must record calls, and how they're going to monitor that and deal with that without causing problems with psychosocial hazards. Interesting, different challenge. New regime for psychological injuries. Everyone would have seen hundreds and thousands of bits of information talking about bringing claim for damages, for work injury damages against an employer where there's a psychological injury. The threshold has moved up to 25% whole person impairment. I don't read one article where it doesn't say the chances of getting to 25% are negligible. I have done many disputes in regards to psychological injuries. I'm yet to see a 25% whole person impairment. Maybe I have been unlucky and haven't seen someone so psychologically injured, but in my mind, the number of people that will bring work injury damages claims is very negligible. So that's the first part. And it keeps going up over the next couple of years, up to a 31%, and we will be where we are. I think we will see work injury damages claims for psychological injury as a memory in the past. So that's how we will play out. There's also a capping of how many weeks that you can get compensation. You can keep going provided you got to the wonderful thresholds for work injury damages, but that will have the same effect. So effectively, we're going to find that we have psychological injury treatment for 12 months, no more than that, and it's actually going to be 52 weeks. So of weekly payments, that's going to be challenging. And add that with more defences and definitions that will define when you can bring claims, and it's going to be much harder. Now, the concession for doing that, because we're going to have claims, is there has to be initial payments made for 8 weeks for medical treatment, and 75% of your wages gets topped up if you get a successful claim backdated to the day that you had the injury, but that's effectively an interim payment, and you don't reimburse it if you don't have a claim. So that's going to go out the door towards the worker for the first 8 weeks, effectively. And just remember this, with relevant conduct, there's a time frame that claims have to be decided in. And you'll see that 8 weeks plays into that shortly. And commutations, settlements, there will be the ability to settle up a claim for an amount of money subject to court approval, but that's where we'll go. So, new speed of claims, 42 days. Woohoo! Good luck trying to get someone to go and take statements. They're all busy at the moment, and collecting the evidence as an employer to see what went right, wrong, or in between becomes a challenge, because the insurer, iCare, and its scheme agents needs to get that information to make a determination. Let's say you get all the information to them in a time. They have the time to make a decision. They've got 42 days to make a decision. Missed by 1 day, the claim's deemed accepted. So we now have a real challenge that an employer has to make sure that its scheme agents are doing things on time and quickly. Now, if a decision is made no, the worker can ask for a review, and they've got a decision in 14 days. Same consequences if they don't do it in time. So that's a review by an independent person in the insurer that they have gone and done that. And then, and only then, after there's 2 no's, can there be an IR dispute over relevant conduct. So that's the process now. During that 42 plus 14 gives you 8 weeks process. You then get provisional payments during that entire time. So you're covered off as a worker during that time, but only at 75%. Now, what people need to know is that you've got to fill in a claim form. It's got to be complete. If it's not complete, it's got to be rejected in 3 days, or you lose your opportunity to say it's not complete. If a worker doesn't complete the claim form, they've got to keep providing the information, and the clock doesn't run until the information is provided. So there's another one, the 3-day to reject an incomplete claim. Super important. That's probably the most important one for employers, for a very simple reason. You've got to give information about what your claim's about. And we'll look at the claim form very quickly in another slide. So looking at all the claims, we have definitions. This is just an example of the definition for psychological injury. So that's what the court will now interpret. Then we have a definition, I'll do one step. We've got definitions for harassment and bullying as well. But this is probably the key point for people to take away, because this is the defences employers have. So for workers, they've got to overcome these challenges to be able to get compensation. So first of all, there has to be a relevant event, okay? So there's a list. Fall outside the list, you don't get workers' comp for psychological injury. Sorry. Step number 1. 2, that event must cause your primary psychological injury. So that's a causation issue that has to be linked to that event, not to something else that has happened, but to that event. Next, there has to be a real and substantial connection between the relevant event and your work. So that's another additional element that's got to be satisfied. Then finally, employment's got to be the main contributing factor to the injury. Now, they're all prerequisites to a claim, as well as you actually have a psychological injury. And everything is not a psychological injury when it comes to how you feel in response to something that goes wrong. So they're the prerequisites. as well as satisfying the definitions. The first one, which you saw, of psychological injury, I'll just go back to that to see that. A psychiatric disorder that causes behavioral, cognitive, and psychological dysfunction. If you don't have one of those, you don't have a psychological injury, and everything is only applying to psychological injury. Gee, it's getting complicated. Then prerequisites, then a definition of what relevant conduct is. Important to know, repeated behaviour, acting unreasonably. They're the key to relevant conduct. Repeated, one-offs don't count. It's repeated behaviour, acting unreasonably. So that's another area that will be subject to dispute. Excessive work demands, when we look at that, they're going to be beyond the requirements expected of the worker's role. It's got to be repeated and persistent. Sorry, or persistent. Very important. Repeated is much less than persistent. And it has to not be reasonable in all the circumstances. That's the definition for workers' comp. So that definition is going to be interpreted by the courts at some stage. The sexual harassment and discrimination type provisions follow very much on the back of where we see them in Commonwealth legislation. Nothing particularly new about that. Bullying must be repeated. Sexual advances don't have to be repeated. They just have to be unwelcome. So these are where we're looking at things. So those, it's all a matter of reasonable, what people have done, and these are the definitions we pick up. And relevant event contains its own definitions. Relevant event means relevant conduct plus other defined events. And so looking at those other defined events, the first one is relevant conduct. This gives you your entitlement to psychological injury compensation. Bullying, sexual harassment, racial harassment, excessive work demands, and anything they stick in the regulations at a later time. That means you don't have to go back to the Parliament to make changes. They can add to the list of relevant conduct at any time. They can use that to form what will be matters to trigger compensation. And one of the examples I give you, if you went through the Managing Psychosocial Hazards Code and you added every one of those into the regulation, that would make it very challenging for employers, because it would import into the Workers' Compact everything that's in the code. That hasn't been done. That's something that may, in part or in whole, be done down the track. But that's the relevant conduct triggers, which forms a subset of relevant events. Then we have relevant events, which acts of violence or threatened violence, being exposed to indictable criminal conduct, witnessing a traumatic incident happen, coming across a person seriously injured at the scene of a traumatic incident, or having vicarious trauma. Both traumatic incident and vicarious trauma has been defined. Traumatic incidents, suicides, attempted suicides, anything the regulations tell us later down the track. Seeing someone objected to violence, a criminal event, natural disasters, car accidents, or other accidents. Accidents are a very wide term. So if you see something goes wrong that harms someone, you will fall within traumatic incident. There's also a definition of vicarious trauma, which in essence is you're exposed to something over and over again. a police officer, if the legislation applied to it, who has to attend a scene of a crime regularly, has to attend a home to find someone who is deceased. These are the traumatic experiences they're exposed to, and if you're in that type of a role, that's where traumatic incidents will be. We have nurses, don't we? That's probably the largest area I see vicarious trauma jumping towards. It's interesting. But these are all triggers for the claim. Now, if I can't find one of these, I don't have an entitlement to psychological injury claim compensation. So, facing relevant events, you face a fast-track system for bullying, harassment, excessive work demands. No change to the existing process for other relevant events. I've got the Industrial Relations Commission for relevant events, and I've got the Personal Injury Commission for both relevant events and relevant conduct subset. So I think we've got a duplicated problem for people, because potentially where you have bullying, harassment, and excessive work demands, you could face two disputes. A dispute in itself can cause psychological harm. So we now have two, which is perhaps something that will not be helpful. However, we have to deal with what we have in legislation. There are more strengthening of ways to resist claims for employers where it comes to bullying, harassment, and excessive work. It is now an objective test, so it's not what the person feels or perceives. It is what objectively they have, or what objectively a person would do in their position. Trouble is, it was changed slightly because a provision was added before it finally passed to add that the worker's perception is also a factor, but only if it's a reasonable perception. So we're still going to have debates over whether or not someone's perception is reasonable as part and parcel of an objective test. The more you add, the more difficulty it becomes. The more difficult it becomes, the more the law will take time to evolve to interpret how we will have what I call an objective test with an implied element of perception, but only where reasonable. Interesting and difficulty. And we have defined criteria for excessive work demands as well. So not all excessive work demands will fall into excessive work demands. So once again, you've got a tick list that you'll have to go through to see whether or not the conduct that you complain of as a worker falls within excessive work demands. And most workers' solicitors will write to a doctor or a psychologist and say, do you believe there's been excessive work demands? And so the interesting outcome will be reports that will just say excessive work demands without looking at the areas that will be covered, potentially is open to challenge because it might be conduct that didn't fall within the category. So this will impact on people that treat workers and need to write reports. So another thing, and remember, this is only the subset of relevant conduct that it applies to. Now, excessive work demands are easy. Usual work patterns, supervision, control, roles, responsibilities, work arrangements, how much you pay people, what remuneration should you expect from that remuneration. It's very different what you expect from a $200,000 a year employee to a award employee. Workplace needs is a factor that's relevant. Staffing levels, mix of quals, industrial instruments, all of these feed into what is excessive work demands and are all considered as part and parcel of the process. So we've got a tick and flick list that people will need to consider when thinking about bringing these claims. One of the things we always have had is we've had defences, which we in the workers' comp industry were known as Section 11A defences, which were in essence that no compensation was payable where there was reasonable management action. So if the significant cause of the injury was any of these three, then that's a defence to the claim. Reasonable management action taken or proposed to be taken, tick. Next one, if the injury, the significant cause of the injury is the worker's expectation or perception as against what was done, tick, excluded. Or if the perception or action taken in relation to the worker all relates to their perception, tick, it's out. So if it's their expectation, if it's their perception, it can be kicked out as well. And that also will apply to what we call secondary psychological injuries, which flow as a consequence of a physical injury. So the defences have been tightened, and it's significantly tightened because perception has been removed. There's still the tests of what's reasonable. However, that's where we move to. Now, the next part we move to is action must be taken in a reasonable way, and it must be taken, it must be reasonable in all the circumstances. Two-limb test. So for you to satisfy as an employer, you've acted with reasonable management action, you have to satisfy both. That's a I'll call that a hurdle that you have to jump over. Otherwise, miss one and you miss the defence. What's reasonable management action? There's once again a tick list. And the tick list, what does it apply to? There's no great difference nowadays because in disputes in the workers' comp court, people focus on what are we talking about in terms of issues when it comes to the action that's complained of. Appraisals, workers' performance, counselling of a worker, demoting them, changing their roles, disciplinary action, performance management, looking into misconduct by a worker or by someone else. If we are doing this, these are all capable of being reasonable management action, but you need to bring your action within that list. In addition, there's promotion of a worker, giving them leave, providing employment benefits, reclassification of their roles, suspending them, standing them down, training, transferring their employment, reclassifying their employment, communicating on all of the above. They are all things that can amount to reasonable management action where they're reasonable and it's reasonable in the circumstances. Anything that falls outside of that list can't be reasonable management action unless regulations come along and add to it, which is potential. And it's pretty hard to think about something that doesn't fall within that list. There's a few: introducing you to a new IT system, introducing you to new software, providing you with no training on a particular thing. You would have to bring yourself within the training category. So you have to be mindful that not everything will be excessive work demands. In summary, when we look at workers' comp claims now, we've got to satisfy the definition of psychological injury. It's got to come from a relevant event. The event has to satisfy the definitions in the relevant events. There's got to be a real substantial connection between the event and the worker's employment, and it's got to be the main contributing factor. So then an employer will defend it by saying there's no bullying or harassment, the work wasn't excessive. A tribunal has already found that it wasn't excessive. So if someone's ventilated a stop bullying order, you might find that coming back in your face if you were a worker. Finding of bullying or harassment doesn't link to the event. That is, it's nothing to do with the employment. That a significant cause of the injury was reasonable management action, then it's out, or that the perception of the worker was the real reason there's an injury. All of those are the defences. So we have a much more complex regime where employers will have remedies. The important part I mentioned earlier, that there's a new claim form. Just cast your eyes over the list of matters that have to be included in the claim form. Specific examples of instances, including the time, date, and location of the conduct that is said to give rise to the bullying, harassment, or excessive work. Persons involved in the conduct, witnesses. You've got to explain it. Now, I'm going to bet that the claim forms we get don't have much information in them, because that's the way it proceeds at the moment. Those claim forms are incomplete unless they include all of this. There is boxes in the claim forms to fill that out. Most people filling in forms skip over boxes. So that's going to be an interesting challenge, because if I'm an employer and I haven't got all the allegations, I'm going to want you to reject that claim form. And if the claim form's not rejected, I'm not going to be a happy camper as an employer. And as a worker, I haven't gone off and seen a lawyer. I've just filled in a claim for workers' compensation, and I've got to go and give all of this information. And if I don't give, I'm potentially missing out. It's going to be very hard for workers to navigate their ways with the new processes, as much as it's going to be hard for employers, because that level of detail on the new claim form is quite significant. So that will be a challenge. The next challenge we're going to find is what an insurer has to look at. The insurer, when they do get the claim, they've got to take into account what the worker says, what witnesses say, date and time of the accident, what was the relevant event, what was the conduct of everyone, what's the medical and other information, what information the workers got, whether there's been reports off to the police, the unions, the employer, safe work, etc. All of that has to be taken into account. I've got to make a call in 42 days as an insurer. I've got to collect that information in 42 days as an insurer. And if I don't have information that gives me the view that there's reasonable grounds for disputing a claim, there won't be a dispute. Or at least the insurer will say, I accept the claim. That if an employer vehemently disputes liability, will introduce a need to have good working relationships with their scheme agent, very good working relationships. And it creates a whole role for other stakeholders to become involved in this area. Not that they're not there already, but that's where it will become an issue. And like everything, the claim forms can be improved, and the evidence that must be considered can be improved by the government passing regulations adding to the list. So we don't need to go back to the Parliament to change it. They can be done by regulation. So relatively easy, we can change what has to be supplied, and we can add to or take away from what has to be supplied and what has to be considered. That's the strategy in terms of that. Resolving and defending workers' comp claims that are disputed will become a challenge, because they will pop up in the Industrial Relations Commission where there is a conciliation, because the process will be conciliation first, hearings later. That will mean, how are you going to settle the claim? are you going to settle it? Because the theory is you shouldn't contract out of workers' compensation rights. So you can't settle with a deed. However, there's not workers' compensation rights unless you have an injury caused by relevant conduct. So we may see a return to the past where cases were settled where you ask a tribunal or a commission to make findings and note admissions made by a worker to settle cases for closed periods. This is a very interesting thing that existed in the past, and the scheme moved away from that because they didn't want cases to be settled up by way of deed releases that released employers from all obligations. So all I can say is time will tell. We will see what develops. But at this stage, lawyers will be the ones that govern this. ICARE's lawyers will probably be instructed not to draft settlement documents that include findings and admissions. So potentially that will preclude a way to settle the case other than you lose, Mr. Worker, or we agree you win, Mr. Worker, but only for a short period of time or a set period of time for your wages. So it will be interesting to see how resolution at conciliation develops. It will be interesting to see whether or not there is the element of other types of claims that can be caught up in the settlement at that conciliation, e.g. unfair dismissal claims, adverse action claims, and other claims that a worker probably has when they have a psychological injury. And of course, you can always run a case and prove there was no bullying, there was no harassment, there was no excessive, or that it was reasonable management action. So that's how we're going to dispose of claims. Employers, what you need to go and have a look at, you've got to go and have a look at your return to work plans with particular focus on managing bullying and harassment and excessive work demands. You've got to look at your suitable duty strategy because you're going to have a problem if you don't provide suitable duties. The fines are up. They're only $12.50 for not complying with an improvement notice for suitable duties. However, that's a real issue. That's not something covered by workers' comp. And your performance management process will need to be much more documented, much more controlled, and much more prescribed if you want to try to establish the performance management process necessary to bring defences. So that's what you need to look at whilst looking at your WHS system to see if you paid sufficient or any attention to the Psychosocial Hazards Code. And I am betting that those who have bought WHS systems off the shelf some time ago will have systems devoid of any reference to psychosocial hazards. So it's important for employers to go back and have a look at that now. There's a real challenge when you have a psychological injury claim on the investigation and how you manage it, how you're going to appoint people. Some employers' first reaction is to go off and get lawyers to do the investigations. The bad news for those employers are those investigators probably become witnesses in a case and can't act in a dispute. So it's quite interesting that a lot of law firms don't realise that. But if they get pulled in to do investigations, they may well be witnesses in the case down the track. And once you're a material witness in a case, you can't act in a dispute. So this is an interesting area that will develop. You will see law firms develop new companies where they have people in those companies doing investigations. So that's where we will see things. Evidence. To have a claim, you've got to get it right before you get it going. You've got to have the policies, you've got to have the processes, you've got to have the procedures to take interviews properly, you've got to deal with people being able to have support persons at interviews and the like. You need to have the rules clearly articulated, readily available, and readily producible to the workers' comp insurer so they can see that you've got the processes and you've acted reasonably and you've followed your processes. Getting the documents together late is going to be impossible. You've got 42 days. Good luck getting it all together if you don't get it ready at the start. And then whilst you're doing that, you've got to look at your other insurers if there's any other types of claims that are pursued. Unfair dismissal, adverse action, whistleblower, stop bullying orders, stop work orders, and whether or not you've got any other insurance that's triggered by those claims that you should be notifying as well. So, what can you cop if you have a psychological injury? Stop bullying orders, stop sexual harassment orders, unfair dismissal, adverse action. Off you go to the Fair Work Commission, unless you're not a constitutional employer, and then you can pick those all things up in your Industrial Relations Commission effectively. Federal court, you can go off for adverse actions, and as I mentioned earlier, you can get compensation. You can also seek civil penalty orders, which are penalties against the company for breaching legislative obligations. Sexual harassment damages claims in the federal court, industrial relations, suitable duties, disputes, terminations, reinstatement applications, relevant conduct disputes, and guess what? We still have the Workers' Comp Commission or the Personal Injury Commission that does your run-of-the-mill workers' comp claims. So this jurisdiction in the Industrial Relations Commission, which I've said applies to government employees, it extends beyond that, and people just need to know it's really for it's really for businesses that are not constitutional corporations, partnerships, etc. There's a fair amount of this. So this is a brand new jurisdiction. This is a jurisdiction that people will flex into because it gives you an entitlement to damages very different to the Fair Work Act. Damages where work injury damages claims no longer have a role in claims because it all turns on whole person impairment thresholds. Watch this space. This will be a growing space in local government, councils, government agencies, and the like, because there is now a way to step around the workers' comp restrictions on damages. This will be interesting. This will be a change. What's the relevance of the WHS to workers' comp claims? Not a lot. But a lot. It will inform what's reasonable and what's reasonable management action. So if there's legislation that suggests, or a code that suggests you should do so, acting in accordance with that code will demonstrate you've been acting reasonably. Acting outside of that code will demonstrate that you're not acting reasonably. So not only will the code be relevant to your compliance and obligations that arise under WHS, it will inform defences to workers' comp claims. So that's important to know. So the code is not governing of a workers' compensation claim, but it will inform the defences and whether or not you have acted reasonably. So the WHS considerations for a breach of the code or a breach of the digital work requirements is not much different to, or it is no different to what we needed to look at before. How jobs are designed, organised, managed, what we ask people to do, what equipment and environments we provide, What are the social factors at work? All of these inform what an employer must do to provide a safe workplace, and also what they must do to comply with the code and to comply with digital work obligations, and ensuring that doesn't introduce psychosocial hazards. You've got to look at the nature of your employees, their youth, their literacy, their background, their numeracy, their disabilities, and that needs to inform what you do with dealing with work health safety obligations and duties imposed under the Work Health Safety Act. Look at the past. How have they been traumatized? Or look at the past and see what they've been exposed to, and that needs to inform your response to the code. All of those are existing obligations for safety, which have now been brought one step further with the code. And when we are looking at risk, and it's a simple matter, we've got to identify reasonably foreseeable risks. I now have a list in the code, so they generally are reasonably foreseeable. In the old days, we used to have asbestos claims that would jump up, and everyone said no one knew about asbestos. Then there was a state of medical knowledge that became known within employers. And from then on, you had the situation where people knew about the risk and you had to take action against it because the risk was foreseeable. That's what this code has done. It's foreseeable. People cannot say a risk that's in the code isn't going to be foreseeable. The risk controls are not spelt out as well, but that's all right, because that's a matter of a risk assessment needs to be carried out by a business every time it identifies a hazard. We don't need a book with 5 million risks and 5 million categories that are all the same. That doesn't work. You've got to evaluate what happens in your business. You've got to identify your risks, and you've got to introduce measures to eliminate and or control the risks. That's what we all have to do. And in doing that, we have to have a fair, transparent system. We need to have consultation. We need to get feedback from workers, and we need to consider their views when we look at the harm that can be caused. This is not new. This is what we need to do. But what is new is that we have the checklists and the foreseeable risks that have been articulated in a clear way now. So, WHS duties, make sure you do these 6 or 7 tick lists. Consult your workers, pretty easy. Provide a safe system of work, bit harder. Provide and maintain a healthy working environment or a good work environment without risks. It's getting harder, isn't it? Particularly if you've got conflict, which is a driver of a psychosocial hazard, or you've got attitudes or environments that are not conducive to a healthy workplace. Monitor people. We do that through various means. We do it through consultation, we do it through surveys, be them confidential or non-confidential. So these are all matters that need to inform the behaviour of an employer. We have to provide information, training, supervision. It's not enough to say the manager was the bully. I haven't had no way of dealing with that. The owner was the bully. They're all breaches of your obligation to provide proper supervision, instruction, and or training. Small businesses can't just say, hey, I was the owner. Local councils can't say, when we come to this, exposing yourself to difficult counsellors doesn't amount to bullying. So it does. So there is an interesting play around that. So we've got the 5, and then there's 2 more. We have to control. And if it's not capable of being controlled using reasonably practicable things, we've got to minimise. Simple and easy. Easy said, not easy done. It's very challenging to deal with psychosocial hazards, particularly with perceptions. I've given you a list extracted from the code of the very simple things that give rise to psychosocial hazards. They're not new. They can be read. I don't need to take you through it. They're there. Job overload, job underload, traumatic events, conflict, loss of control, no role clarity, bad relationships, poor support, managers that don't do the right thing. It's obvious. We face it on a day-to-day basis, but you've got to do something about it now. That's the trick. You can't just sit back and say, off we go. Workplace violence can't be tolerated. Bullying can't be tolerated. Harassment. Complaints that you don't escalate and deal with. Inadequate rewards. Ripping people off because you give them too much work. Sending them off bush without the support. And probably the biggest challenge is the second, that poor organisational change is always a challenge, but not having procedural fairness when you deal with someone in regards to a complaint, a performance management, an issue that arises, an investigation. That is why we need really good documented systems around that place. So we look after psychosocial hazards. We then have to get our return to work plans sorted out so we don't get some fines, and we must deal with psychological injuries in the same way as we do physical injuries when we're looking at return to work. Very difficult when you have a person who's been bullied by a direct report and someone they report directly to, and that person is the only one in that role they can report to. So suitable duties are still an obligation that you have to provide. They were there before the changes came and they continue to apply. And they don't apply if there's no injury. There's no injury if there's not relevant conduct, where there's bullying, harassment, and excessive work. Okay, so that wonderful first 6 weeks where you can dispute things is really critical to your return to work plans and your injury management plans. Interesting. So you can't just sit back and say, I've got a workers' comp claim. You can't sit back and just say, I might be prosecuted by Safe Work for WHS breaches. You can't just say someone might come in and give me an improvement notice because the union says I have to improve safety. There are other matters that will arise. Adverse action claims and unfair and unjust dismissal claims if you dismiss someone. If you have a worker dismissed because you have constructively dismissed them. That is, you made it so hard they had to resign in the circumstances. So you cannot just deal with these psychological injury claims in isolation dealing with a workers' comp claim. There are all the other ramifications we need to deal with. And those other ramifications you need to think about as an employer, what you would do in terms of your insurance. Do you take out insurance that will give you employment liability protection against adverse action claims? My suggestion is all employers should, but it isn't without cost. Should you have processes to notify your insurers? Because if you've got those insurers, there's certain obligations. Can you use your own lawyers? It depends on those different insurance policies. You may have to appoint another insurer. Those policies will also have problems because they will be subject to a premium, excesses, limits, sub-limits, aggregate limits, may not be able to trigger investigation costs until there's actual proceedings commence. So it becomes a bit of an insurance play. And with insurance, people have to look at it. They've got workers' comp, which is compulsory. You have other insurances you can take out that may come into play depending on the nature of the claim, or you may decide to do it alone and simply say, that will be my business expense. I will simply deal with it as I deal with it. So that is all I wished to run through today. I hope that you've got a little bit of a choke point, seeing how much there actually is, how complicated it actually will be, and how it's going to develop slowly over the years. And I do mean years. It will not be days. We don't have a wonderful process where the court comes back and just says, here it is, here is a particular decision you can apply generally. Some courts do, but the Industrial Relations Commission doesn't do that at this stage and won't get an opportunity to do it for some time. So remember, this started 1 July. So even if I filed a claim today on the 1st of July, the clock is ticking. There's 42 days. It's in regards to an injury after 1 July. After the 42 days, someone hopefully has got a note out if it was going to be disputed. Then there's a request for a review and there's a 14-day tick over. The request for the review is by the worker, not by the employer. They can't come along and say, I don't agree with the insurer's decision. It's only the worker that brings the review. And then after that 14 days, if it goes against the worker again, off you go to the Industrial Relations Commission. And in that meantime, someone might have ventilated a dispute in the Industrial Relations Commission about a workplace matter or a work safety matter. And you might find yourself facing two things. And I can tell you now that the workplace or the work safety matter dispute, if it's going, is not part and parcel of what iCare will look after. So there we go. I'm not sure how we have timed. I've gone far too long, I expect.
No, I think that's my fault, David, thinking that we could get all of those reforms discussed in less than an hour. That's on me. But it has been incredibly informative, and we're actually going to keep it open to do some of the Q&A sessions. We've got about 5 or 6 questions, I think, in the chat, so I can just start reading them out if you like.
Absolutely.
Did you want to stop sharing so we can see your face a bit bigger? And what I've also done is I shared your LinkedIn profile in the chat, so you may get a few requests coming through to connect with you, because there is an incredible amount of change and it is very confusing. So you definitely have helped to give a really great overview of those. And what we're going to do after this is actually create a psychosocial safety briefing. So we'll embed the video there and add any more additional information, the links that you shared as well, and anything else that you'd like to add to that. So some more content. So we will get that out to people as soon as we've pulled that together. But again, David, huge thank you. All right, let me roll into the questions. So we have one of them. Do work health and safety representatives have the same power if they're not elected and are only a rolling voluntary position?
Not the same power as a committee, but they're a worker and they have all the powers of a worker, so they can deploy those powers to ventilate a dispute over a WHS safety matter.
Fantastic. Thank you.
Doesn't quite need to have that robust. However, an individual ventilating a dispute and running off to ultimately the commission will be at their cost. It won't be funded anywhere. That's where it is. Whereas others might do a hat whip around if they want to go and have some legal proceedings.
Okay, very interesting. Now, this question comes from Tony Morris from SafeTM, who you have met in the past in the courtroom. And
Absolutely.
his question is, does the new Division 5 for work health and safety disputes make redundant the old section where an inspector can be called in to settle the dispute? In other words, if you can now go direct to the IRC, why would one call in an inspector to settle a dispute now?
That's exactly what I would not do. I would run off to the IRC. The only issue is that the interplay, Tony, I reckon is going to be, we will see more people ventilating issues. We will then see lodgement of notices which have to be sent off to the regulator. And then we're going to see that they have to come out in 7 days. So you might find, let's make it hard for the employer, complain, get them to notify the regulator so you don't do it yourself, and then you run off and get a dispute in the commission. That's what I think unions might come up with a strategy to work around.
Yes. Yes. So Kanae has asked a couple of questions. One of them is, do you see bullying becoming a criminal offence in New South Wales and Queensland as it is in Victoria with Brodie's Law?
That's like that's a Dorothy Dix question to some extent, because we have very different governments with very different strategies. It's very hard to see where they're going. In particular, you look at some recent legislation that Victoria has introduced, which say in terms of sexual harassment claims, they've said that no longer can you have non-disclosure provisions in any deeds or documents to settle up sexual harassment claims. I think they're very much leading the way on being worker and victim supportive. Whether or not New South Wales jumps onto that, they tend to follow, but a little bit slower or in a different way. I saw the same thing. We've got a whole lot of changes with home warranty insurance and approving different forms of insurance. Victoria has led the way on those changes, and New South Wales are a little bit behind. I don't know why that is, but that just seems to be the process at the moment.
Yeah, great. Thank you. A couple of good questions here too. In a toxic environment where bullying and harassment is endemic, is there a grace period for employers, or can employees begin seeking compensation immediately?
The only issue is repeated. If it's toxic and it's repeated, you're in problems from that day. So one-offs, not an issue, but you have to react immediately once it's a continuing, unreasonable, repeated position. All you have to do is look at your left-hand side of the codes that identifies all of the hazards, come back and say, what's a reasonable response to that, and am I acting reasonably? That's for a workers' comp claim. And am I doing everything reasonably practicable from a work health safety perspective? And if the answer is no, you're in trouble. What do you do if you've got someone being victimized by someone in a workplace? You've got to remove one or the other or both. So you can't let it continue. So no, there is no real grace period, but there must be repeated.
Yep. Another one that I also get asked, and I know a lot of providers in the area get asked, and I know you probably do as well, because a large number of workers may have a pre-existing condition, for example, existing trauma, depression, anxiety, grief. How are these pre-existing conditions related to when considering the impact of the injury? How are they going to look at that?
The wonderful thing is we've got a provision in the workers' compensation legislation that includes an aggravation or exacerbation of an injury. And what is the causation factor? Is it the aggravation, acceleration, or exacerbation of the injury? That's your answer. And so you can't change a fact. If a person's incapacity is a result of a previous event and that's ongoing, that's not an issue, because it's not your employment's not the substantial contributing factor. Remember, we had the 5 prerequisites. That's where you sit. And so that's how it's going to be moving forward. But you do have aggravation, acceleration, and exacerbation that triggers, if that's what's led to your straw that broke the camel's back, then that's what happens. It becomes an injury that's compensable.
Yes, and we always say work shouldn't make things worse. So everyone has different backgrounds, but yeah, work shouldn't make things worse.
And that becomes a very difficult medical issue. And a lot of these disputes revolve around medical issues and medical opinions and what people perceive or don't perceive, because that's what the courts determine when they look to see if there is a causal link between an event and the incapacity. It's just a very difficult issue. I mentioned earlier that we can get damages for an adverse action claim, a personal injury caused by the adverse action. But I have to get a medical practitioner to say that injury is caused by that adverse action as against everything else that went on. So then I have to have this arbitrary or artificial attempt to apportion it. 50% of that was related to what was happening in their life, and another 50% was related to that adverse action. So I'll only compensate you for that 50%. So unfortunately, we don't have the law which comes to mathematical calculations, and I don't think we have crystal ball tellers that can, in any real way, apportion. And it's lawyers that ask doctors to apportion between various things, which is all but impossible. But it's what the evidence we need to inform the outcome. So it's very hard.
Yes, agreed. And thank you for the explanation. This second question, and we just have 2 more questions to go, but the second question from Kenay Dias, who's also on our board and the founder of Alchemy Workplace Solutions, she's asked, can you provide more information on the Australian Human Rights Commission complaints process? Are workers using this pathway specifically for gender, racial, age, and/or disability discrimination complaints versus the other jurisdictions?
The starting point is there. You make a complaint and then you run off to court. That's in essence the process. So it's used everywhere. Traditionally, it wasn't used at the start because the outcome, you didn't get compensation in essence from the complaint. You had to then run off to the federal court to bring and ventilate the claims. Federal court can be very expensive. One of the drivers in all of these claims, or all of these nature of claims, are lawyers. Lawyers, a lot of them do work on spec, so no pay, no win, no charge. Employment's rife with problems for lawyers because many of the jurisdictions are no-cost jurisdictions, where you are not entitled to recover costs. So it's a bit of an industry, unfortunately, in my view. And that industry proliferates because there's a bag of cash that is there at the end of the day. And the poor worker that should be getting reasonable notice or compensation ends up losing some of that compensation because there's no cost compensation that is payable. So it's an interesting area. I think we'll see more and more disputes in the federal court in relation to those racial discrimination, sexual harassment, age, and other disability claims. So that's where we will head in the future as lawyers look for money, as bad as that seems.
Yes. Let me go to the last question from Dr. Helen Lawson Williams, who is the founder of Tank and is aiming to end burnout. And she said, in some industries, you could argue that the usual work pattern is inherently excessive. So, as you've said as well, for example, trainee doctors and nurses, and unsurprisingly, we see high rates of harm in those sectors. Does the EWD definition prevent those workers from successfully seeking intervention?
I think you can bring yourself within that relatively easy one of the categories. I take doctors and nurses as an interesting one. They've been treated abysmally for years and years. They weren't adequately compensated for overtime and the like. They have them, but their employers, particularly governments, have found class actions brought against them for excessive hours and not remunerating them properly. Guess what that leads to? That's really easy. It's clear that taking into account the remuneration they received, it wasn't reasonable to have them work that hard. So therefore, they've got an excessive work demand claim without any doubt, to the extent there's a psychological injury. Has to be a psychological injury, not just they felt stressed. So it's very much to get those workers' comp claims, and that's really what only excessive work demands are for, or the definition is really just for the workers' comp claim. That's what you've got to satisfy for a workers' comp claim.
Mm.
And so I would drive a bus through the opening if someone tried to argue that doctors, nurses, and the like hadn't been exposed to excessive work demands where they weren't properly remunerated for it. So you can always find a way.
Great explanation. Thank you so much. And David, really appreciate your time. Taking 2 hours out of your day is not an easy thing to do. So really grateful for that. But for anyone listening to the replay or anyone right now, what is the best way for them to connect with you if they want to get in touch or learn more or connect?
I'm on LinkedIn somewhere. That's fine. I don't know whether or not in due course you'll be sharing the presentation, the lot or whatever. That might be a way that you can do that. That will have my details on it. And other than that, if anyone wants to scribble down the name of the firm, which is Newey Bond, the website might be down today, but it's relatively easy.
We'll add those links as well so people can connect with you easily. Yeah.
So there you go.
Fantastic. Thank you so much again, David. Really appreciate it.
Pleasure.